On Monday, July 29th, 2024, the Ashley Benefield trial continued with day 5 of testimony. And on this day, the jury heard from 7 more witnesses, this time all for the defense, before the defense rested their case in chief. Most importantly, we got to finally see some experts testify for the defense, to include a DV expert, a returning licensed mental health provider that we've heard from before, a forensic scientist, and a forensic pathologist. To me, although they were not able to take this testimony as far as I think they would have liked, overall, this was a good day for the defense and a good way for them to end their case in chief. Now, the big question will be, what does the state's rebuttal bring and how will closing arguments shake out? Let's get into it. Okay, so at the end of day 4, we talked about how there was a Daubert hearing where the two sides were battling over this question as to whether Bruce Ferris was going to be allowed to testify as a DV expert. And right off the bat, to start the day on day 5, we found out that the court in fact did admit him as an expert in DV. Personally, I thought this was the right call since he's definitely qualified to talk about the subject matter with all of his experience and education, and because his testimony clearly can help the jury to understand a lot of dynamics in abusive relationships as well as common tendencies by both abusers and victims of DV. It's because DV and a lot of the behaviors around it don't always make sense to people who are unfamiliar with it. DV victims will do things like go back to their abuser, hide their abuse from friends and family, cover for their abuser, and more, which the rest of us might look at and just say that just can't be real. How can anyone in this situation do these things? They must not actually be a DV victim. And so because these behaviors are not necessarily obvious, it's very helpful to have an expert to explain how these things happen and why in these specific circumstances these behaviors actually do make some sense. Anyway, so like in the Daubert hearing, Ms. Ferris's testimony focused largely on the Duluth Power and Control Wheel, which he said is used nationwide on a regular basis to identify and understand DV behaviors by both the abuser and the abused. Here's how he explained it.
So this is what's referred to as the Duluth Power and Control Wheel. And so there's physical violence and sexual violence. Those are the criminal things I talked about. And then there's these power and control aspects. And the nature of the power and control is repetitive. It's a way to get control. So up at, we'll call it 1 o'clock, using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons would be an aspect of intimidating your partner, again, to gain control. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy, playing mind games, humiliating her, making her feel guilty. Then isolation, controlling what she does, who she sees and talks to, what she reads, where she goes, limiting her outside involvement, using jealousy to justify actions. Then a big one that I see often is minimizing, denying, and blaming, making light of the abuse, not taking her concern seriously, saying abuse didn't happen, shifting responsibility for the behavior, saying she caused it. Another one is using children, making her feel guilty about the children, using the children to relay messages, using visitation to harass her, threatening to take the children away, male privilege, testing, treating her like a servant, making all the big decisions, acting like the master of the castle, being the one to define men's and women's roles, using economic abuse, preventing her from getting or keeping a job, making her ask for money, giving her an allowance, making her ask for money, not letting her know or have access to family income. And the last one is coercion and threats, making her carrying out threats to do something to hurt her, threatening to leave her, saying that he'll commit suicide, reporting her to the government, making her drop charges, making her do illegal things.
And so he said that the central factor here is the common goal of the abuser is to get compliance of the victim. And he said they'll do this by using coercive control. And this is an important point for anyone to understand DV. According to Mr. Ferris, coercive control is where the abuser uses any number of acts of aggression, assault, threats, and potentially more, all to frighten the victim into compliance. Importantly, it does not require physical violence. And this is important, especially because the prosecution has made a point several times throughout this trial, and especially in Ashley's cross-examination, to say, well, you said he never punched you, he never hit you, he never wielded a club against you, that kind of stuff. And so here, Mr. Ferris is explaining that regardless of whether there's any physical violence here, what matters is that the abuser has made the victim believe that physical violence is possible at any point if she is non-compliant and if her non-compliance is strong enough. And so, looking back at the Duluth power and control wheel, Mr. Ferris said that each of these compartments on the wheel are all tools used by the abuser against the victim to achieve this end. And it's important to note that it doesn't need to be the case that all of these factors are used in every single DV case, but just that enough of them are used on enough of a patterned basis to create these cycles of abuse, or rain and sunshine periods as Mr. Ferris described them. These cycles of abuse that he's talking about are where the abuser first does something on the wheel to exert power and control over the victim that is big enough that it might scare the victim. Then the victim distances themselves from the abuser apologizes, the abuser then acts very kind and sweet, the victim then forgives the abuser and returns, and then the abuser ends up doing something again that starts the cycle all over again. Now, this Duluth power and control model uses gendered language, as did Mr. Ferris, but it's not because he was saying that all abusers are male and all victims are female. However, he did say that this is the way that I guess a majority of these cases actually shake out. He said 2/3 of abusers are male and 1/3 of abusers are female. And for victims, he said that number is basically swapped, although the proportion of female victims may actually be higher than 2/3, maybe as high as 3/4. Now, in terms of describing the victim's behavior, Mr. Ferris said that the end result of these cycles of abuse, where the abuser is trying to achieve compliance by the victim, the resulting behavior by the victim is walking on eggshells around the abuser. Another way that he described it is the victim will basically try to achieve an equilibrium stasis in the environment, so where she tries to manage things so that nothing rocks the boat to upset the abuser. And this is because she's learned over time that when the abuser is upset, he's going to get aggressive, and she's going to be put in immediate fear that the abuser is going to do something potentially dangerous to her. And so this means that there is also a strong motivation by victims to hide the abuse from other friends and family members, because of course this information getting out could be yet another thing that upsets the abuser. And in some cases, Mr. Ferris said that the psychological impact of minimizing the abuse and explaining things away also can reach a point where the victim doesn't even realize that they are a DV victim at all, because they've internalized all of that. Now, another important point that Mr. Ferris made was that he said having a child in this environment typically will exacerbate these issues. He said that there's a much higher correlation between DV abusers and people who will commit acts of animal cruelty, and particularly when we're talking about a pet that is cared for by the DV victim. And the same is true with children, who Mr. Ferris said the abuser will use as yet another tool for abuse. This can be threats of harm to the child, threats to take the child away, and more. And this is especially the case if the DV victim has some strong maternal instincts, because she's going to be much more willing to sacrifice herself in order to protect the child. Now, finally, Mr. Ferris also touched on what he said is, statistically speaking, overwhelmingly the most dangerous time for any DV victim. And this is the time when the DV victim is leaving the abuser and the abuser is aware that the victim is leaving. It's such a commonly known thing among people who work in the field that DV advocates often have safety plans for these periods of time. And of course, the defense wanted to highlight this because this is what the defense is saying, is that Doug actually knew in this moment that they were not going to be living together, although everyone was moving to Maryland. And so this fits as one of those categories of she is leaving Doug, Ashley's leaving Doug, and she's making that very clear to him in private. Now, before cross-examination, defense attorney Neil Taylor asked Mr. Ferris a couple of hypotheticals. And these were where he asked if these were situations where Mr. Ferris would find DV to potentially be present. The reason these were in the form of hypotheticals is because Mr. Ferris was not asked to evaluate Ashley individually, so this part of the testimony was limited to hypotheticals. Here's one of them.
So, Mr. Ferris, I'm going to give you a series of hypotheticals, and I'd like you to tell us if it's consistent with abuse.
Yes, sir.
Shooting a gun in the kitchen of a home in an effort to intimidate the victim to stop speaking. Throwing the loaded gun at the victim. Cruelty to pets. Punching a dog in the face hard enough to knock the dog unconscious. Throwing a cat down the steps. Placing a tracker on the victim's car, an illegal tracker, throwing things, breaking things, yelling, screaming, belittling, cursing, humiliating, declaring such statements as rid the earth, being in a murderous mood, kill all the bad people, take them out, being caught at night, peering into windows of the victim's home, violating a no-contact order by sending a package, driving from South Carolina to Florida to be able to follow the victim, suicidal threats if the victim leaves, more than 30 years age difference, and finally, prior marital history whereby the prior wife explains how she was beat up on the honeymoon. Would that be consistent with abuse?
Absolutely, and not only absolutely, but those are checklist points right off the Duluth Power and Control Wheel and right off my experience. They're stereotypical abuse techniques.
Then Taylor ended by asking, now what if there was a break in the chain of events by, say, as much as a year or two, and then it started all over again? Does the victim remember the prior trauma, and is this considered consistent with a DV situation? And to both of those questions, Mr. Ferris answered pretty emphatically yes. Now, in cross-examination, the prosecution was able to score some points here. And basically what they were trying to do was to more or less make it look like the Duluth Power and Control Wheel is something that anyone can just sort of pick out and see what they want to see. In other words, if somebody wants to see that there's DV there, they can just cherry pick things over time and say that there's abuse. I don't know if they fully succeeded in doing that, however, especially if the jury was truly paying attention and understanding the fundamentals of DV that Mr. Ferris was explaining and the way that the Duluth Power Control Wheel is used to that end. But the prosecution did score some points by pointing out some things that might be inconsistent with DV, and these were all points that the state has been hammering so far. For example, the state put this in terms of hypotheticals, but basically pointed to things that had happened in this particular case and started with pointing to, for example, the isolation part of the wheel. And here she asked Mr. Ferris, well, does this sound like DV if the alleged victim was living on her own with her family and paying for herself, and she was basically had no monetary connection to the alleged abuser? And understandably, Mr. Ferris responded, no, that's not really consistent with finding DV. And then she pointed to the factor of using children as a tool for abuse. And she asked, well, what if the alleged victim is physically separated from the alleged abuser and has total custody of the child and tried to terminate the alleged abuser's parental rights? And Mr. Ferris said, yeah, in that case, I wouldn't necessarily say that DV would apply. And so then the state really tried to hammer in that they basically just believed that Mr. Ferris was too rigid in his beliefs and that he was basically just someone hired to parrot what the defense wanted him to say. But personally, I think that this may have backfired somewhat. This may have been what we often like to call the one question too many, when you really try to go really deep into your point, but you go just a little too far and you give an opportunity to the other side to better explain themselves.
Would you take into account, based on with these factors such as emotional abuse, economic abuse, male privilege, using children, all of these, if the alleged victim, or let me give you a scenario, she does not live with him, she's actually in another relationship, potentially engaged to a new man.
Okay,
She tells him that she does not want to be with him,
okay.
and she plans to move away without him. Would those be factors that you would have to take into account when deciding if that relationship fit this power and control?
Well, that would be factors of the relationship, but I haven't heard you say anything about what their history is, what trauma she's experienced, what's going on with children in their lives, all sorts of other dimensions of their relationship.
I guess, so is there no scenario where there can be abuse in a relationship and then there no longer is abuse, where they are no longer in this wheel? Because the way you're answering your questions, that's the impression I'm getting.
So there, I have come across situations where there's an emotional abuse or a physical abuse, but it's not a pattern or behavior. It doesn't go on over a period of time in an attempt to control someone. So, if I may, if someone pushes down their girlfriend on a night out and he gets arrested for domestic violence because they live together, it's a battery, that's domestic violence, but that's it. she's not appeasing, she's not put an emotion, the whole power and control dynamic isn't happening. That is domestic violence under criminal law, but it isn't domestic violence in the sense of a pattern or behavior to try to get the appeasement or this sort of consensus out of a victim where they're afraid to poke the bear, all the things I've already talked about. So if that answers your question.
It didn't. Is it your testimony that once a relationship has these power and control aspects, that is forever, even if there's no continued allegations of abuse for years, no continued allegations of abuse, no continued allegations of emotional abuse, never any allegations of sexual abuse. The parties are living apart. They're independently, I keep saying independently wealthy, that's not what I mean. Independent, economically independent. They are, the female is telling him she doesn't want to be with him and has moved on to a new relationship. Is there no scenario, in your opinion, where people can get off this power and control wheel, even if they were on it at some point in their relationship?
I think it's possible, but it's not likely, and it's not the typical thing that I see. Usually there's still a dynamic of emotional abuse.
So even under my facts,
Yes.
with no allegations of
Yes.
no allegations of emotional abuse in years,
Yeah.
it's your opinion that not good enough, they're still on this power
Well,
control wheel?
all I can speak from my critical learning and studying this, and also my practice, and I have custody issue couples where they're domestic violence, and 10 years later, there's still abuse taking place, even though they're remarried and don't live together. So by example, I see continued abuse. Could there be a couple that don't? I'll say it's possible.
Thank you.
So here, Mr. Ferris gives a much more nuanced explanation of how these abusive relationships can actually continue over time and what sort of factors are really required in order to analyze these things, as opposed to taking a lot of these minor things out of context. But nevertheless, the state was able to make those points that leading up to this encounter, there was in fact a gap of time where Doug was not acting in as domineering or controlling of a way as he may have been before Ashley left for Florida. And so the jury might actually look at that and say, this makes her fear less reasonable. Personally, I don't agree with that logic, but there are plenty of people disagreeing with me in the comments to all of these videos, especially since my video talking about Ashley Benefield's testimony. And of course, the jury could have the same perspective as those people. But let me know what you think in the comments down below. Okay, so next up was the defense's fifth witness, Gianna Torchia. She worked with Doug's attorney, Stephanie Murphy, and her testimony was much, much shorter and to the point. Basically, the purpose of calling her was to call into question this idea that Doug did not violate the South Carolina DV injunction by sending the package to Ashley in November 2017. And so the focus of the testimony was specifically on an email chain between Miss Torchia and Detective Gillum about the package that he had sent and about the DV injunction out of South Carolina. Specifically, it seemed that the defense was most interested in when Stephanie Murphy's office had a copy of the South Carolina injunction. And so, did this move the needle all that much? Personally, I don't really think so. In comparison to everything else that the jury heard, especially on this day and on the day before, this is probably the least impactful testimony in my opinion. Anyway, next was the defense's sixth witness, Vincent Vizzaccaro. He is a realtor in the Bradenton area, and apparently he worked with Doug, who was looking to either buy or rent in the area, depending on who's asking the questions. And specifically, he testified that Doug looked at buying a particular home that just so happened to be right behind where someone else was living. Mr. Vizzaccaro testified that he didn't know who lived at that other home, but the suggestion was heavy from the defense here that this was the home that Ashley was living in with her mother and with Emerson. Now, we did hear testimony all the way at the beginning of this trial from Doug's cousin, Tommy, who said that Doug had actually looked for a place to live nearby in Florida so that he could be nearby Emerson. So someone on the jury who isn't exactly with the defense at this point might not see Mr. Vizzaccaro's testimony as all that big of a deal. And on cross-examination, the state got out of the witness that Doug said that he ultimately was looking to rent as opposed to buy, and that he said that he needed to talk to Ashley first before making a decision. Now, he could have just been telling the realtor that. People tell things like that to realtors all the time, or that could have been, in fact, where Doug's mental state was at. But if there are jurors who really took in Mr. Ferris's testimony about DV and the Duluth Power and Control Wheel, they might see this as Doug attempting to bridge that gap and start asserting control over Ashley again by moving literally into her backyard. Anyway, then the defense called their seventh witness, who the jury will absolutely recognize. This was Dr. Jason Quintal, who was being recalled after testifying in the state's case in chief. And this was interesting because now when he was being called by the defense, he was being called as a follow-up to Mr. Ferris's testimony. And this time, Dr. Quintal was actually qualified as an expert in psychology, so he was able to testify about certain conclusions he reached in the process of counseling Doug and Ashley. Now, this was a good move by the defense because although Dr. Quintal didn't use the same specific language that Mr. Ferris used, and although he didn't talk about the Duluth Power and Control Wheel, for example, he did talk about things that really echoed a lot of the things that Mr. Ferris was talking about. For one thing, Dr. Quintal talked about his goal with trauma resolution as opposed to basic traditional therapy.
When we speak of trauma resolution, explain to us what that is.
So I think the first thing that somebody has to understand is trauma, or what we go through, isn't troubling because it happened, which is the conventional wisdom, is that because it was awful, it still hurts. But we're not troubled because it was bad. We're troubled because when it happened, emotionally the brain short-circuited and doesn't know that particular experience ever ended. So where therapy missed the boat is we felt that people buried and repressed, and we have to help them process and get it out of them. Where the methodology that I use is the reverse. It's about getting the good news in to the emotional part of the brain that doesn't know it's over. Think of it more like unplugging the memory, so emotionally the brain can read it as data about something that happened versus where it's been stuck as happening. Which explains why when somebody frequently either talks about it, is reminded of it, or is in something similar to it, emotionally they're transported back to that awful moment, right? If you have a friend telling you about something that was troubling them, and as they're telling you about it, it's almost as if they go back there to that troubling moment. So our goal is to keep the person more emotionally present as we unplug the emotional effect that the past has had.
And this is interesting because it identifies what's going on in the brain when someone is, over the long term, still wrestling with prior trauma. And although he didn't narrow this down to how, say, a DV victim might experience trauma, from everything that we've heard about trauma so far, we can see how this fits actually to fill a gap in these cycles of abuse. In other words, we might have a victim who may not be in the moment getting actively victimized by the abuser, but the victim's brain just might be holding the victim in that space of terror because they have this feeling like that danger hasn't ended, even though the abuser is actually currently being nice. And so this also helps to explain why there might even be, say, a longer drought, so to speak, between these aggressive incidents and why the victim might still be in fear of the abuser long after that latest incident. And this point is especially important to the defense because it addresses a key weakness in their DV self-defense argument, which the state has definitely been trying to exploit this entire trial. Anyway, then Dr. Quintal testified about conclusions he reached about Doug specifically.
Did you reach any conclusions with respect to Douglas Benefield?
Yes.
Would you tell us what those were?
Based on the conversations with both Ashley and Doug, Doug occurred as someone who was domineering and the terminology that I would use at times would be super controlling. He was very dedicated to wanting the relationship to work. He was very interested despite conversations with some of the disparaging things that Ashley had said to him. He was very much still wanting this to work, and their plans were to move to Maryland.
All right. Did you reach any conclusions with respect to him being a real alpha male? Do you recall?
I would say that Doug occurred as somebody who was very built and well put together. And yes, I would say that he would fit the stereotype of an alpha male, in my opinion.
Did you conclude whether there was an intimidation issue present?
Ashley stated that she was scared of Doug.
Did you reach any conclusion, Dr. Quintal, about whether Doug's depiction of himself as being godly was reliable?
Objection outside of expertise?
Overruled.
You can answer.
Can you say that again, please?
Sure. Did you reach any conclusion with respect to Doug's presentation of himself as being particularly godly?
Yes, I think it was over the top.
All right, and did you reach any conclusion as to whether it was genuine?
I did not think it was fully genuine, no.
So this is also important for the defense because it shows an independent person who is evaluating both Ashley and Doug individually and together. And there's also the point of corroboration. Ashley said in the weeks or months leading up to the shooting that she was in fact afraid of Doug. Of course, the jury has to evaluate whether that fear was in fact reasonable, but it's helpful to the defense to be able to actually show the jury that at least someone else was there who was objective in this whole thing can say that she did in fact report that fear to him before all of this went down. Okay, so next was the defense's eighth witness, Detective Justin Warren from the Manatee County Sheriff's Office. Detective Warren was the lead investigator in the case, and I was most interested in what he was going to say because remember, I found it kind of odd that the state did not call him to testify in their case in chief. At the beginning of the direct examination, it became clear that basically the whole purpose in calling him was so that the defense could grill him on the quality of the investigation. Taylor started out by asking him if he was in charge of directing the investigation and about the fact that Detective Warren concluded that Doug wasn't facing Ashley when she shot him. But then the state objected and they had a whole exchange outside the presence of the jury. And ultimately, Judge White cut out probably the bulk of the testimony that Taylor was hoping to get in. This was testimony like how Detective Warren determined that this was a murder within hours, maybe even within an hour after investigating the incident. And it also included testimony by Detective Warren at a previous deposition where Detective Warren apparently said that it was basically his general belief that every homicide was a murder. Now, the reason why Judge White excluded this was because Florida has a longstanding rule that you can't call a witness for the sole purpose of impeaching that witness. Rather, the witness has to have given some kind of substantive testimony first, which then triggers a credibility issue, which can then be impeached. And while I understand this rule, and I think it makes sense, I definitely agree, I think that the defense just didn't do a very good job in crafting the argument as to why this testimony wasn't just impeachment evidence. Specifically, I think Taylor could have done a better job of explaining to the judge that this wasn't just to impeach this guy. This was to get substantive testimony about problems with the underlying investigation, which then led to the arrest and the charge of the defendant, and how those amount to foundational problems in the state's case that then give way to reasonable doubt. As an example, we saw this in spades in the Karen Reed trial, of course, where the Canton PD and the Massachusetts State PD had some serious flaws in their investigation and how this impacted the reliability of basically anything they touched. But here, because Taylor wasn't able to draw this out to a wider scope like that, the bulk of it ended up getting cut out. And so he was then basically limited to asking about two things. First was that he did not speak with the medical examiner before getting the arrest warrant to arrest Ashley. And second, he asked about a portion of Detective Warren's supplemental report where he was basically supposed to indicate if he had any kind of bias. But because most of what he wanted to ask ended up getting gutted, I'm not so sure that the jury is going to be able to take much of this away substantively, however. Anyway, then the defense called their ninth witness, which was Michael Haag. He testified as an expert witness in forensic science. And specifically, he testified about being able to piece together information about the trajectory of the bullets from Ashley's gun, as well as overall what happened with these various gunshots in the scene. He started off by saying that there were 4 gunshots total. And because Ashley used hollow point bullets, he was able to figure out which recovered projectiles went through Doug and which ones did not. This is because hollow point bullets are designed so that they get stuck in the first person that they enter, essentially, as opposed to easily going through one person and then into another person. For example, someone who happens to be just standing right behind them. And so as a result, these are generally considered safer-ish. And Mr. Haag said that they do this because the hollow point inside the bullet, when it travels through something liquidy, like a human being, it fills up with that liquid. And in doing so, this ends up opening up the front of the bullet so it sort of blossoms out or folds backwards. And this creates drag for the bullet as it continues to go through tissue. So if a hollow point bullet was found on the scene and it was largely intact and it doesn't have those folds out of it, then you can probably figure that it didn't actually go through a human or anything that is liquid for that matter. So the first bullet that Mr. Haag talked about was the one that was found actually in Doug's back. Obviously, there is no mystery as to what happened with this round. Then another bullet was recovered after going through one wall and into the bathroom area. And Mr. Haag testified that because this one didn't have that sort of folding pattern backwards that I just described, he concluded that this round was one of the rounds that missed Doug. And to be clear, he said that it was deformed, collapsed really because of hitting the wall, but this looked different than what happens when it goes through tissue. Anyway, then he said that the third bullet was recovered basically down the hallway. He said that this bullet had no signs of any soft damage on the nose, like what we would see with it passing through liquid, but he did say that it had a flat spot and striations on it that suggested that it had actually ricocheted off of something. And so his determination was that this bullet ricocheted off the tiling floor, where there was a mark that basically corresponded with this in between the bedroom of the shooting and the hallway area where it was found. Anyway, then the fourth bullet was found just basically hanging out on the floor of the bedroom. And he said that this one did in fact show some soft damage, meaning it looked like it had passed through some tissue and then out of Doug's body. However, he could not determine a connection between where it was found and where it rested on its own because it looked like it may have been kicked around the room during, say, life-saving measures by first responders. Now, one thing that he did say that was important was that he couldn't make any conclusions about the ordering of the gunshots based on the physical evidence in this scene. However, he said he could conclude as to whether he thought Doug moved during this incident.
Do you have an opinion as to whether or not the deceased was stationary or moving?
If we assume that the firearm was relatively stationary, and by that I don't mean a matter of 3 or 4 feet, I mean the firearm is not circling about the room, going out in the hallway of this incident or otherwise. If we take the position that the firearm is generally just in the bedroom and is pointed in the same relative direction as the two trajectories that I've described for you, then it would have to be that the decedent was in motion, because we have trajectories in the decedent's body that are almost opposing. We have one that goes from, as described in the autopsy report, and this is how it's commonly described in such things, front to back, right to left, and as I recall, relatively flat. I think it was maybe slightly downward, but I've forgotten the vertical component. But the key factor is that one goes this way, and as I read the autopsy report, the other gunshot wound enters the inside of the right leg and comes out the exterior outside of the right leg. These are basically two relatively opposing trajectories on an object that undeniably, in my work, objects, bodies, regularly move in between shots for one reason or another. So given that, to me, those trajectories in the body indicate to me that the body was in motion.
And then he also said that he thought that Ashley moved at some point specifically between right and left.
All right, and with respect to the firearm itself, are you able to draw any conclusion whether or not that was in motion as well?
Certainly within the degree I've described before with the two trajectories that I can show you, the one that goes in the wall, for those that I can demonstrate by physical evidence, there was some motion. And as I recall from my measurements in the 3D scan data, it's something like 4 or 5 feet at least from one position of one trajectory's area over into the area of the other. As an approximation, again, because again, trajectories are approximations. Otherwise, beyond that, no.
So would it be safe to say that your conclusions support the fact that both the deceased as well as Miss Benefield would have been moving from right to left?
I can't tell you that the firearm moved from right to left at those shots. A statement of such would be supported by those two trajectories that I mentioned.
He also confirmed this with some 3D modeling that he put together and compared the standing positions between the mist round that hit the wall and the mist round that ended up down the hallway.
If I take you to the side of the cone here, the far right side of the rightmost cone, our most right option, from that position directly over it, if you look down the hallway area, you actually, there, they'll fill in, you actually cannot see where that bullet struck the wall. This area right here is to the right of the bullet's impact site. We actually have to move, as I will now, over into this area. And I'll get us right at the edge of the wall. We have to come all the way over here in order to get to the impact site, which from my examination of the images is more in this area. So somewhere on the tile in here is a bullet impact site, a ricochet off the floor. That bullet goes on and then barely perforates the drywall or penetrates the drywall up in this area. So
And that's another bullet, is that correct?
correct. Sorry, I'm on to bullet 19, as I recall, was its designator for those two.
Let me recap for just a minute. So one goes in the wall, and then one goes down the hallway.
That's correct.
And again, you can't say which shot was first or second.
I don't have physical evidence that would allow me to establish that, correct. But that bullet in the wall down there also expresses no soft damage. It is also one that did not strike the decedent.
A miss.
A miss.
All right.
So from the 3D laser scan data, and I don't have a good trajectory or a good impact site to look at here. I was unable to go in and examine the floor. If I'd been able to find that impact site, I might have been able to refine that trajectory into the wall a little bit better and give us a more defined trajectory. But other than the ballistic accessibility aspect of going down that hallway, I can't do that here. Just they're two separate trajectories that have some slight divergence in the lateral aspect.
And finally, when he presented some 3D modeling that he had put together, it showed that the trajectory of the bullets found showed that when Ashley shot at Doug, she was standing and pointing slightly downward.
And in fact, if I put plus or minus 5-degree cones, I talked about the error earlier, on both of these, we can see that those two cones look like that. That's actually a 10-degree cone for each of them, the green and the blue. And so from the data that I have for this case, for this one shot, I would include any area within that cone, either one of those cones, as the area where the firearm would have been at the time that shot was fired. I can also show you this from the side view to give you an idea of the vertical component. So I'm going to remove the left wall of the bedroom as you're looking at it here, and I'm going to swing you down. And from this vantage point, you can see how there is a downward component to these shots as well, going into that, I believe, again, number 11 hole within the bedroom.
Would that be consistent with Miss Benefield firing the weapon while she's standing in the upright position?
There are certainly multiple places along these cones where a shooter could be standing. So basically any hypothesis or any scenario that puts the gun in those cones, including that one, would be on the table.
Now, importantly, on cross-examination, the state did point out that these angles that Mr. Haag was able to reconstruct with 3D modeling were only of the rounds that didn't hit Doug. In other words, he did not have enough physical evidence to be able to definitively say where and how Ashley was standing when she actually shot Doug specifically. And he completely agreed that he couldn't give an opinion as to those rounds, so he did not fight her on this. And so this is an important limitation in his testimony, but the jury will still be able to nonetheless get more of a picture of where and possibly how these things happened on September 27, 2020. Now, the final witness of the day was the defense's 10th witness. This was Dr. Emma Liu, a physician and forensic pathologist who used to be a medical examiner. She testified, obviously, about the various wounds on Doug's body. Now, one thing that I think I may have missed from Dr. Vega's testimony, the medical examiner, is that there actually was a third bullet wound to Doug's body, and that was specifically to his arm. Dr. Vega basically described this as a superficial abrasion on his arm and suggested that this bullet basically skimmed his arm but didn't really get him. Now, Dr. Liu testified to the same thing and said that the wound traveled up, backwards, and slightly left to right on Doug's arm. Then she talked about the chest wound and explained the same trajectory that Dr. Vega had testified to before. And after that, she detailed the leg wound, also in the same way that Dr. Vega had testified. However, one thing about her testimony that was different than Dr. Vega's was very, very interesting. Where Dr. Vega said that there was really no way that he could tell which bullet hit when, Dr. Liu said that she actually thought that she could. And this is because she picked up on a very specific detail about the chest wound that she said was very significant. Particularly, she said that as that chest wound projectile traveled backwards in Doug's body, it nicked a part of the bone of his spine. And she explained that the purpose of the bone is, of course, to protect the spinal cord. And she said that she's actually seen this happen many times in bullet wound examinations that she's done in the past, where a bullet hits just the bone of the spine. She said that when that happens, even if the bullet doesn't hit the spinal cord itself, hitting the bone will cause shock to the spinal cord. And she said that the result of this is paralysis of the body, where a person loses use of his legs and can end up falling flat on his back. And so her conclusion was that the upper arm graze was the first shot before it ricocheted down the hallway. And by the way, the reason that bullet didn't open up the way a hollow point bullet does when it goes through tissue is because it basically just barely grazed him. She said it didn't pierce him enough for this tissue to end up inside the hollow point. And so that would explain why he ended up with just an abrasion from that one. Anyway, then she said that the second gunshot wound was the wound to his chest. She concluded that because it hit the bone in his spinal cord experienced that shock and he lost the use of his legs. And so she said this was in fact consistent with him falling with his legs sort of flying in front of him because he lost control of them. And she said that this is where he would have gotten the third gunshot wound, the shot through the leg. I will say, this is one of the parts of Ashley's testimony and the defense's case where I think I had the hardest time with. When Dr. Vega said that it was unlikely that his legs would just sort of fly out from under him, I agreed. I thought that it sounded kind of outlandish, especially without him falling backwards over something else. But this explanation by Dr. Liu gives admittedly some credibility to this claim that his legs did in fact fly upward and that Ashley shot the leg after shooting him in the chest. Now, one more point that Dr. Liu said fit very well with this theory is the fact that Doug also had an abraded contusion on the back of his head. This is essentially a really bad bruise from some kind of big impact. And she said that it was very likely that as he was falling without any control of his legs, his head either hit the wall or hit the hard tile floor just outside the entrance to the hallway. Now, on cross-examination, the state basically said, well, you're not saying that this is the only way that this could have happened, right? And of course, as any reasonable professional would say, Dr. Liu said, no, there are multiple possibilities. However, this is a very good one. But then the state said, well, that abraded contusion to the back of Doug's head, could that also be consistent with the EMTs dragging him out of the house and on the way out, like knocking the back of his head on like the door jamb, for example? Dr. Liu kind of stopped like with this skeptical look, but then she said, well, with enough force, I guess I'd say that that's possible. And during that exchange, I remember thinking about it, like just how uncareful would the EMTs have to be in carrying him out for that to happen? Like it does seem like it would require a lot of force and they would have to be really, really clumsy for that to happen. That's just my impression. Again, I'm a layperson. I'm not a medical expert by any means, but it did seem like that was a little bit more of an outlandish suggestion by the state to say that, no, that's the way that that happened. But then again, they still have rebuttal to come, and maybe they are planning to bring in an EMT or two who will testify to that happening specifically. And maybe they'll come in and be like, yep, we're total klutzes. We just dropped him right on his head on the way out. Now, I'm also curious to see if Dr. Vega gets called in back on rebuttal to respond to Dr. Liu's testimony, specifically about that spinal nick part. But anyway, after Dr. Liu finished her testimony, the defense rested their case in chief. Then they went over some matters outside the presence of the jury and then basically finished for the day. Now, day 6 should be the state's rebuttal case, and depending on how long that goes, we might see some closing arguments on day 6 as well. So we are nearing the very end of this trial very quickly now. Honestly, I was so on the fence during this entire trial until the last couple days. But between Ashley's testimony, the experts who testified about DV and the psychological reasons for Ashley's and Doug's behaviors, and the forensics in this case, I'm fairly convinced at this point now that Ashley was indeed acting in self-defense in connection with the trauma of being a DV victim. But those are just my thoughts. What do you think? I know opinions are very, very split on this case, so if you think I'm wrong, tell me in the comments where I'm missing something. And if you can, more than just she had fake tears. I would like to hear specifics on where people are leaning one way or another and what kind of evidence, what kind of testimony is specifically causing them to lean in that direction. And otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more daily recaps of this trial or more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out. And if you're really loving the content and you want to know how to best support the channel and get perks like early access to non-trial recap videos, consider becoming a member of Fight Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you on day 6.